Welcome to the Currency of Knowledge, a County National Bank wealth management podcast, the podcast where we unravel the layers of prosperity, explore the diverse meanings of wealth, and delve into the stories of those who have built their own versions of abundance. I'm your co-host, Christopher Phillips.
And I'm Holleigh Baker. Join us on this insightful journey as we redefine wealth beyond the balance sheets and uncover the true riches that life has to offer. Let's explore the essence of wealth in all its forms. Welcome to the Currency of Knowledge, our educational series. Christopher, you and I get to sit down today and talk about estate settlement, which is very important and a big piece of what we do in the wealth management department.
Yeah, it's kind of a traditional trust company function, and we take that responsibility of carrying out someone's final wishes very seriously. And I think it's important for people to understand that the process takes some time. There's some complexities in it. And so today I hope just to talk about a little bit how you can help prepare your family for what will eventually happen to all of us, is that our final affairs will have to be settled.
Yes, and hopefully in a smooth transition. And having done this for many years, I always think it really comes at perhaps the family's worst time because their loved one has passed away. And if you don't have your plan in place and you don't have it set out properly, there are some speed bumps that you hit. And us here can help them navigate that and hopefully make it a very smooth transition during a very difficult time.
Yeah, I think what we would know by conventional wisdom is that divorce and death are two of the most stressful events one can experience. And we all will experience death at some point, and we will all have a family member who will pass away. And so we need to be prepared for that. So I think before we start going through kind of the just logistics of estate settlement, trust and estate settlement, maybe we could just take a step back and talk a little bit about how you as the living person might prepare your family to set them up so that they can successfully navigate through the trust and estate settlement process.
Sure. So as we sit down with clients, we walk them through what is your estate plan. And really that estate plan at a bare minimum should be a will. And then a lot of clients move into the need for a trust and then all the other documents that come with it. But from our perspective as a corporate trustee, the will and the trust, so whether we're personal representative or executor for some, not in Michigan, and then successor trustee, helping our clients formulate what that plan is, get them to the right experts, so the estate planning attorney, to help them draft it up, which is really just two documents that are going to say who's going to step in after I'm gone and what I want to have happen with my assets, whether it passes outright to individuals or to charities, or maybe it's held in trust for some period of time because there are certain needs that have to be taken care of. But that's our job to help them craft that, get them to the right expert, and then ultimately settle it for them.
Absolutely. And one of the functions that after the estate plan is created, if you did a trust, is to go ahead and to fund that trust. Oftentimes the questions that we ask clients when we're meeting with them is simply, have you funded your trust? And funding the trust, just to define that a little bit, is simply transferring the assets that can be transferred from your either individual or joint names into the trust that's going to control those assets upon your disability or your death.
Yep. It is interesting because along with the trust, you still have to have a will, a pour-over will. And we do get that question a lot. Well, why do I have to have one? Because I have a trust and you just told me to fund everything in my trust. So why bother having the will? And that's because I probably forgot about the one asset up north.
Right,
to put into my trust.
Yes. And so once the assets are funded and you have them in trust, one of the things that I think is helpful is to make sure that you tell at least one family member or your trusted advisors, whether it's your CPA, your attorney, your financial advisor, is where the original documents are stored. So where's a good place to store those documents?
Yeah. So the first thought is always my safe deposit box. And we've learned over time that is not the place to store it because I don't have access as successor trustee or personal representative. If I've stored it in my safe deposit box and I'm the only one on it and I pass, you don't have a way to get into it. So a lot of times, either the attorney will keep it on file or in your safe at home.
Right. Yeah.
That's where ours is.
Yeah. Good.
Out of the safe deposit box.
So now and then the second piece to that is kind of a running list of your balance sheet.
Yes.
So that the successor trustee, whether it's a spouse or a child or a friend or an institution like County National Bank, we have at least a roadmap of where to get started to collect those assets and to identify what those assets are. Yeah. Do you have any thoughts on how you might do that?
Yeah, well, and it's even more important because all of us do everything electronically. I don't get paper statements anymore, so you can't even have my mail transferred and start getting my statements. So, couple of things. I have a book that a client actually turned me on to, which I think is what happens after death or something along those lines. And I actually have information written down in that book, which again is with my estate documents. But I've also said to clients, along with a list we'll probably talk about later, which is things that you can just say, I want you to have, like a ring or something. I would just leave that list of the different statements or institutions that you've worked with. I would leave it with your actual trust document. And if you're working with a corporate trustee, if you can give us a copy and we can scan it in with your documents. And it just is a help. Again, especially if we're not getting paper statements.
It begins the roadmap of who to contact. Absolutely. We know that assets and places change. You may have a CD at one institution that matures and then it moves to another place. We can do a pretty good job at tracking that. Where it gets somewhat challenging is when we don't have that place to start. And we have to figure out, where to kind of begin. And then to that extent, though, we do have ways to do that. And we would start oftentimes with the income tax statement.
Absolutely.
Because we're going to see on that income tax statement through the 1099s and all the interest and capital gains, that sort of thing, where the income is coming from, and then we can backtrack to find those assets that way. That takes a lot of work. That takes a lot of time. There's a lot of confusion. You want to make sure that the trustee can pay ongoing bills because just because you've passed away, house insurance still has to be paid, real estate taxes still have to be paid, the utilities still have to pay, those sorts of things. So you want to be able to give quick access, but to the extent that there's not, the income tax statement is a good place to start.
And we have, at times, have a relationship with a beneficiary or a family member, and they can provide some insight. But you're absolutely right. The tax return or any other documentation that we can get our hands on is helpful. Yeah.
So let's fast forward a little bit now to where the events have happened.
Yeah.
And your phone's going to ring, and it's going to be a spouse or a child on the phone and say, Mom or Dad has passed away. What do we do? So what's the first thing to do?
So the first thing we would do is we check the document. We make sure that we are, in fact, successor trustee or personal representative or both. And then we meet with the beneficiaries. And there's statutes and laws that we need to follow. There's certainly a timeline. We have so many days to get notice out to beneficiaries of the trust. We have to file notice to creditors to get the statute running for different claims. But once we've established that we are, in fact, successor trustee, then I believe that the most important thing is get those individuals in that need to know, okay, here's what the process is going to look like. And here's about how long we anticipate it's going to take. And that really is anywhere from at a bare minimum the 4 months because of the statute of limitations for the claims period, meaning if you have claims, you can come forward, to potentially 2 years?
It could be 2 years, yes.
Given the complexity of the estate to settle, if certain tax returns have to be filed because of estate tax, there's all sorts of, there's a huge gap, I guess I would say. So
Yes.
4 months to 2 years.
Yes,
potentially.
it's just like anything else. There's sometimes some things are straightforward and simple, and sometimes they're more complex. And the more complex the estate, the longer it's going to take because we have to process through.
Yes.
The number of beneficiaries also
Yes.
may delay the administration simply because our goal is to communicate the process to all of them and making sure that everyone's on board throughout the way.
The type of beneficiary could make a difference as well.
Yes, absolutely.
You know, whether it's individuals or charities. But what I think we do well is to help navigate them, the beneficiaries, through the process. And so all along the way, from start to finish, we have the communication. And the communication may simply be, we're still in the waiting period. And as soon as we've crossed whatever threshold is required, we can do the distributions. But also to help them understand what maybe they should be doing with these distributions. You know, or the type of, is it a qualified plan, or all sorts of different things. And that is what the extra value we add, because it's not just simply settling the estate and moving on. They still need guidance.
Yes.
In the end.
Yeah, because there's a lot of things that they're dealing with. One, they're dealing with the loss of a loved one.
Yeah.
Which is, again, high stress. Two, they're wondering about, how is this going to affect me from an income tax perspective is oftentimes a question that we have. And inheritance itself is not taxed. However, IRA distributions from qualified plans such as 401ks, IRAs, that sort of thing may be taxable depending on how they receive them.
Yeah.
And then the other question becomes capital gains. How do we handle capital gains, that sort of thing. So we are providing counsel, both trying to make sure that the assets are passed in the manner and the desire that the decedent directed us to.
Correct.
Which is the most important. Secondly, we're providing counsel to the beneficiaries of how they are going to receive this and what consequences of receiving it is. And then thirdly, talking to them about what these assets mean and how they can make them grow so that they're good stewards of those monies.
Absolutely. And sometimes it's also explaining, especially if they're not getting it outright and it is being held in trust, what that looks like going forward for them. Because there sometimes is more to it than just the settlement piece.
Absolutely.
You know, we could have then an ongoing relationship with one or more of the beneficiaries, and then what that looks like for them.
So we divide at CMB, we divide the trust administration up into three parts, three main parts. Acceptance. So during the acceptance phase of the trust administrating, we're really just trying to gather all information as possible. We're trying to take it all in. We start at that point kind of gathering those assets, picking, finding out where those assets are, sending the documents to them, collecting the proceeds from and sometimes that means moving the assets in kind, which simply means if you have an investment account, we're moving it with those investments still intact.
Pepsi for Pepsi.
Pepsi for Pepsi. Also again, communicating what we're finding to all of the beneficiaries in a real-time way.
Yeah.
The second phase of the administration is what's called the distribution phase. This is where we're really doing the lion's share of the work here. We're cutting checks, we're moving assets, we're settling the estate for the beneficiaries. And then finally is I screwed that up.
What was the third one?
It's administration.
And then distribution.
And then distribution. Okay. The second phase of the trust administration is simply what we call administration. This is when we're doing all the sort of paperwork to collect those assets, to make sure that we have the formulas and the trust set forth correctly.
Yes.
We're communicating to the beneficiaries what's happening. This is what is sometimes a frustrating time for the beneficiaries because it's a hurry up and wait.
Absolutely.
We're kind of doing certain things. We're waiting for correspondence. We're making decisions. During this phase of the administration, we're often selling real estate if there's real estate to be sold. So we're communicating that process with the beneficiaries. This is where the lion's share of the work, I would say, that we're front-loaded the work with the acceptance and administration. But again, there's long pauses, and this can be the time where beneficiaries get a little bit frustrated because it doesn't feel like the needle is moving very fast here.
That is true.
Then we move into the distribution phase, which is where we're cutting the checks, we're moving the assets to those people who are intended to get the assets the way the decedent wanted them. And then we're closing out the trust and estate settlement administration, filing final tax returns, all that sort of thing. So again, the process itself in any step is not super complicated mostly, but it's the accumulation of all the steps that make this process just tedious and frustrating sometimes to people who don't do it every day. We do this every day. And so we kind of know what hoops we're going to have to jump through, what hurdles we'll have to jump over, and how to navigate through those.
And do it efficiently.
Because time is money here.
Right.
And then, so we really enjoy the work that we do, and I feel very proud of the work that we do in making sure that every trust administration that we have, the decedent's wishes are at the forefront of everything that we think about as we do that administration.
Yeah, I agree. So I have a question for you.
Okay.
Which is one that I get frequently when sitting down speaking with someone. So why a corporate trustee?
I think the corporate trustee, the quickest and best answer is that, as we talked about earlier, it's a very high stress time for the family, particularly when there's more than one beneficiary. And we all know that siblings squabble from time to time. And also, we also know that there's usually different levels of behavioral finance management, let's say.
Yes.
And so we are removed from all of those conversations at the dining room table, those fights when they were high school and young adults. So we don't have knowledge of that. And so we come in with a blank slate. And not only can we go through the trust administration process in a very consistent and efficient way, but we also can remove some of that burden of saying, Amy sold the house for $50,000 less than what I think she should have got for the house, and I want my $50,000 from her. When in reality, as a corporate trustee, we're getting appraisals to make sure that we're getting the highest and best use from that house. We're negotiating without the emotion behind the family home. No sentimental value to it. And we're just making, the best decisions that we can for the trust and the beneficiaries, because we stand in their shoes as fiduciaries. And so we have to do that. So it's not an emotional process for us. It's a business process that we have defined and documented, and we kind of roll through it step by step. One of the things I'd like to do with the education series is upload a checklist that we have available, that we can make available to any listeners here, that may just help them get a better feeling for what the trust administration, estate administration, settlement process looks like, and help you get a little bit organized in your mind about the process and why it might be necessary for a corporate trustee. It's about a 4-page single sheet Excel spreadsheet
that's a good one.
that lists out pretty much every step by step. Of course, every estate administration has a different flair to it and a different texture. But going back to your original question, Holleigh, about why a corporate trustee, is because we can do it faster, more efficient, which means saves the family money
Yeah.
in the end.
And it keeps the family intact.
Yes, I think that's probably the most important because it removes any agitation that may be there, that may cause a ruffle in the relationship.
Yeah.
I always say to clients when we're talking about trust administration, as the trustee, we can't repair family relationships.
Right.
But we can certainly do everything possible to prevent any further disruption to that family relationship.
Yes. Because that is one of the things that we hear a lot is, I want my family to stay. I don't want my family to fight in the end. And they may never have fought.
Right.
But there are also the outside influences.
Let's talk about that a little bit.
The in-laws, as I like to call them, is siblings may all get along and get along fine. Mm-hmm. But when you have the outside influence, so the wife or the husband, and they're putting in their 2 cents, and whether they mean to or not, but they're bringing up then those past experiences. The older one always got this, and the baby of the family always got that. That starts to create problems, can create problems.
Yeah.
And then when we are the successor trustee, one of the nice things about it, again, is, and I've said this, I have no expectation of being invited to Thanksgiving dinner. And I'm okay with that. But then everybody at the table, family-wise, so if I settled your and Aaron's estate, Miley and Ephraim are still going to always have Thanksgiving dinner. Now, they may say, I'm terrible and the bank is terrible, but we did what you wanted. They're together. And so when we step in, as we've said before during this, we're objective and we don't have those. And we can actually help navigate them through that. And some of that way is potentially the first meeting is only with the beneficiaries.
Right.
And then maybe you allow other, ancillary family members in.
I'd like to tell a story real quick just about that. I had a trust administration once where there was a family heirloom. It was a ring.
Okay, yeah.
And the ring was generational, and it belonged to several, 3 or 4 generations back. It had some value, not a huge value, but in terms of the total estate, not a huge percent, but it was a valuable piece of jewelry. The mother had clear instructions. It was to go to the daughter, one daughter. In-law wanted that to be part of her distributive share. It was a specific bequest.
Okay.
And they really wanted that removed from the total as part of what her third that she was going to get. And that's not what the document said. So it was an easy discussion. But the fact that we had to have the discussion with the in-law, when I think the brother knew, because this was a family heirloom, this ring was always going to the sister. The monetary value was not to be included as part of her distributive share. It became a difficult thing for the family to digest. Again, not super material, but it was emotional because the in-law felt as if that the daughter was getting more than her husband.
Okay.
And from a pure math position, yes.
Yeah.
Absolutely. But that was the document. That was the decedent's wishes.
Okay.
It was in the document. It was clearly documented. But we had to have that conversation. So I think to your point is that because the family, the in-laws don't necessarily have that historical knowledge base or that historical teaching that this ring belonged to great-grandma, it went to grandma, it went to mother, now it's going to daughter, that this is set aside from everything else.
Yeah.
If this was the only item that the decedent had left when she passed away, the ring would have still went to the daughter. Right. The other kids would have got nothing.
Yeah. But what's nice about that is probably as it's coming from the corporate trustee, everyone's hearing the exact same thing. you're providing the interpretation as it is, and everyone could have agreed with the corporate trustee, as that's what the document says, but no one single family member had to say
Yes.
what we said.
You're right. Absolutely. Yeah.
So, it's because we do it every day, it is not hard for us. And it's always so interesting to learn the different dynamics. But it's such an important piece. And like you said earlier, you can't get away from it.
Right. It's going to happen.
Yeah. And hopefully you don't ignore it.
Yes.
Because even if you ignore it, it's still going to happen. It just may not happen the way you had really wanted it to happen.
So I think that's a great segue into a call for action. So if you were speaking to your clients and your prospects and to anyone who's listening, what would be a step that they could take to get organized today, and to help prepare their family for the final act of the trust and estate settlement?
Yeah. So I always start with, honestly, at a bare minimum, have a will done. It's very important, especially if you have little children, under the age of 18. At least lay it out there who's going to get them, because you don't need that fight either. But at a bare minimum, do the will. And then there are a bunch of estate documents that go with it. But it's just a matter of sitting down with you and your spouse, or if you're a single person, just yourself, and say, what do I have? And everybody has something.
Mm-hmm.
You don't have to be the Bill Gates. You have something. What do I have, and who do I want to have it? Or what charity?
Mm-hmm.
And that's really your starting place. And then the next simple part of it is, once you decide who you want to have what, how do you want them to get it? Do they get it all now, or do they have to wait a little bit? I think, and maybe because we do it, it seems simple, but I think people don't like thinking about the end, which is hard. But then they get overwhelmed with, who do I give it to, and how do I make it fair? And at the end of the day, it's only fair in your mind.
Yeah, in this case, you're the arbiter of good, justice, and fairness.
Yeah, because probably along the way, even if you split it equally amongst everybody, there's going to be one person who's going to say it's not fair.
Yeah. I would just add to that is that if you've already done your estate plan, this is something that last night we had an occasion to pull out our estate planning documents, reviewing something together as a family. And as you know, I have two children, Miley, who's 22, and Ephraim, who is 18. And I turned to section 2.1 of my document, and guess what? Ephraim is not listed as a child because we did the document before our daughter was born. Now, we had updated our wills several times as we had different sort of revisions about who would become our request to be the guardian for our children. But I never updated the trust document itself. So I have some work to do on that, to get that updated, because it is changing a little bit now that our children are older. So reviewing those documents, providing that list of assets, and updating that annually and sharing it with someone.
Well, and I was going to say, at a bare minimum, review the document at least every 5 years.
Mm-hmm.
You don't always have to pull it out every year. That would be good. But at least every 5 years, or a major life event.
Yeah, like having a child.
Yeah, maybe. Good thing he's 18.
Yeah. Well, thank you very much, Holleigh. This is a great conversation. We would be happy to discuss your estate plan. So give us a call at 517-439-4300 and ask for someone in the wealth management team.